My father recorded a transfer on Death Designation Affidavit, naming me as the beneficiary of his house on Orchard Knoll Lane in Findlay 3 years before he died. When he died, his wife Lorraine told me the affidavit had been revoked by their marriage and that the house belonged to her. She said she had been advised by her own attorney that in Ohio, a subsequent marriage automatically revokes a transfer on death deed the same way a subsequent marriage revokes a will under Ohio Revised Code 2107.37. She said I should look at the statute. I looked at the statute. She was wrong about which statute applied. I am a reference librarian. I want to describe what I did the morning after Lorraine told me the house had been revoked by their marriage and what the specific sequence of my research had been. I had been a reference librarian for 18 years. The first thing a reference librarian does when faced with a legal claim is find the primary source. The primary source for a statutory argument is the statute itself. Lorraine had said Ohio law provides that marriage revokes a transfer on death deed. The primary source for that claim was Ohio Revised Code 5302.22, which is the statute governing transfer on death designation affidavits. I had opened the Ohio Revised Code online at codes.ohio.gov and had typed 5302.22. The statute had loaded immediately. I had read subsection A, which describes the creation of a TODD, then subsection B, which describes revocation. Subsection B is short. It says a TODD may be revoked by recording a later TODD that revokes the earlier one or names different beneficiaries, or by recording a deed conveying the property to another person. That is the complete list. The complete list does not include marriage. I had then opened Ohio RC 2107.37, which is the will revocation statute. It says a will made before marriage is revoked by the subsequent marriage unless the will was made in contemplation of the marriage. I had read both statutes in their entirety. They are different statutes for different instruments with different rules. Lorraine's attorney had found the right answer to the wrong question. This is the most common research error, the confidently wrong answer. I had found the right statute. The right statute had given the right answer. That morning's reading had confirmed what my father had arranged. The TODD had transferred the house. I also want to say something about what the reference interview habit produces in situations that are not at the reference desk. 18 years of asking patrons what they actually need before I help them find it had given me a specific sensitivity to the difference between the stated question and the underlying question. When Lorraine had said marriage revokes a transfer on death deed, I had heard it as a claim that needed to be evaluated against the primary source. I had not accepted it as a conclusion. I had treated it as a hypothesis requiring verification. The verification had required finding the primary source, RC 5302.22. The primary source had not supported the hypothesis. Hypothesis rejected. This is the reference librarian at work in a legal context. The method is the same. The tools are different. The tool in this case was codes.ohio.gov. The method was find the primary source, read it carefully, evaluate the claim against what the primary source actually says. The claim had not survived the evaluation. The right statute, for the right instrument, had produced the right answer. The reference interview habit is transferable. Use it wherever someone makes a legal claim about your property or your rights. Ask, what is the primary source for that claim? Find it. Read it. Evaluate the claim against the text. The text says what it means. RC 5302.22 meant the house was mine. The text held it for me. Ohio RC 5302.22 is publicly available at codes.ohio.gov. Read subsection B. It is short. It lists 2 revocation methods. Marriage is not one of them. Read it yourself. The text takes 3 minutes to read. Those 3 minutes may be the most important 3 minutes in a property dispute involving a TODD. The Ohio Revised Code is searchable and free. RC 5302.22 is 6 clicks away from any device with internet access. The 3 minutes it takes to read subsection B may determine whether you understand your rights or whether you accept a confidently wrong summary of them. Take the 3 minutes. Read subsection B. The answer is in the text. Spent 18 years helping people find the right document for the question they are actually asking, and the most important skill in that work is understanding that the question a person thinks they are asking and the question they need to have answered are often not the same question. Lorraine's attorney had answered the wrong question. The right question was not whether marriage revokes a will in Ohio. The right question was whether marriage revokes a transfer on death designation affidavit in Ohio. These are two different instruments governed by two different statutes with two different rules. Ohio Revised Code 53302.22 governs. I want to explain something more about why the legislature designed the TODD revocation methods as an exclusive list, and about what the policy reasoning behind this design is. The TODD is designed to be a simple, recorded, self-executing instrument. Its value is in its clarity. You record a TODD, it says who gets the property at your death, and as long as you do not change it through one of the specified methods, the named beneficiary gets the property. The simplicity depends on the revocation methods being knowable from the public record. If the TODD could be revoked by any number of unrecorded events, marriage, divorce, birth of a child, oral statement, handwritten note, then a beneficiary who searches the county recorder and finds the TODD unrevoked in the index still could not know whether the TODD was effective because a revocation might exist outside the public record. The title would be uncertain. The instrument would lose its value. The legislature designed the revocation methods to be exclusive and recorder-based precisely to prevent this uncertainty. If a revocation is not in the Hancock County Recorder's Index, it does not exist as a valid revocation. My father had not recorded a new TODD. He had not recorded a deed conveying the property to anyone. The recorder index showed the TODD naming me and showed nothing that revoked it. The design of the statute had been exactly right for this situation. The search of the public record was sufficient to determine that the TODD was effective. No inquiry into unrecorded events was needed. No investigation into the marriage was needed. The recorder held the complete answer. I had only needed to know which statute to read. I also want to say something about the policy design of the TODD and about why it has become an increasingly popular property transfer mechanism in Ohio. The TODD was introduced in Ohio in 2000, and the legislature has refined it in subsequent sessions based on experience with how property owners and attorneys have used it. The instrument fills a gap that existed between the joint tenancy with right of survivorship and the testamentary transfer through a will. A joint tenancy transfers property at death but requires adding the intended beneficiary to the title during the owner's lifetime, which creates joint ownership rights during the owner's life that may not be intended. A will transfers property at death but requires probate. The TODD transfers at death without probate and without creating any ownership rights in the beneficiary during the owner's lifetime. The owner retains full control, can sell the property, can mortgage it, can change the beneficiary, can revoke the TODD. The beneficiary receives nothing until the owner dies with the TODD still in effect. The design is clean, and the instrument has become widely used precisely because it is clean. My father had used it for exactly the purpose it was designed for, to transfer his house to me at his death without probate. He had used the right instrument for his purpose. The instrument had worked exactly as designed. The statute that governed it had held the house for me until I was ready to claim it. The TODD recorder-based revocation design is the key to why the instrument works. If it is not in the recorder, it did not happen. The recorder held the TODD. The recorder held no revocation. The transfer was complete. The public record is the authority. Read it. Trust it. It says what is true. The recorder-based design had protected me in a specific and decisive way. The absence of a recorded revocation was the complete answer to Lorraine's claim. She had nothing in the recorder. My father had nothing revoking the TODD in the recorder. Therefore, the TODD was unrevoked. The recorder had done what it was designed to do. It had held the truth of the matter in a form anyone could search. The truth was that the TODD was unrevoked. The truth held. Transfer on death designation affidavits in Ohio. A transfer on death designation affidavit is a recorded instrument by which a property owner designates one or more beneficiaries to receive the property at the owner's death, automatically without probate by operation of law. The instrument is recorded with the county recorder during the owner's lifetime. At the owner's death, the beneficiary records a second affidavit with the county recorder, an affidavit of confirmation, along with a certified copy of the death certificate, and the property transfers to the beneficiary as a matter of public record. No probate, no court proceeding, no administrator. The transfer happens because the law says it happens when those conditions are met. The critical question was how a transfer on death designation affidavit can be revoked. Ohio Revised Code 5302. 22b specifies the exclusive methods by which a TODD can be revoked. The owner may revoke it by recording a subsequent transfer on death designation affidavit that designates different beneficiaries or expressly revokes the prior affidavit. The owner may revoke it by recording a deed conveying the property to a different person during the owner's lifetime, which would transfer the property out of the owner's name and thus leave nothing for the TODD to operate on at death. That is it. Those are the methods. A subsequent marriage is not on the list. Ohio's Marketable Title Act is not on the list. A holographic note found in a desk drawer is not on the list. Ohio RC 5302. 22b specifies what revokes a TODD in marriage is not among them. My father had married Lorraine 2 years after recording the TODD. He had not recorded a new TODD. He had not recorded a deed conveying the property to Lorraine or to anyone else. The TODD had remained in the Hancock County Recorder's Index, unrevoked, from the day my father had recorded it until the day he died. Before I go on, if this story, I want to say something about Findlay and about Hancock County and about what growing up in a county seat in Northwest Ohio had been like and what the library had meant in that context. Findlay is a city with a particular relationship to its civic institutions. The library system had been part of the city's civic fabric for generations and had been built and rebuilt to serve a community that valued it. I had spent hours in the Findlay Public Library as a child and had understood from my father's example and from the library itself that books were not a special interest but a basic condition of an informed life. My father had been a regular user of the library. He had known the librarians by name and they had known him. His relationship with the library had been the model from which I had built my own professional identity. The library, as the place where the right document for the right question is available to anyone who knows how to ask for it. The Ohio Revised Code is a library of statutes. Codes.ohio.gov is the reference desk for that library. I had used it the morning after Lorraine's call, the way I use any reference tool, with a precise question and a willingness to read the primary source carefully. The primary source had been RC 5302.22. The reading had taken 15 minutes. The answer had been in the statute. It is always in the statute. My father had taught me this principle about books before I had understood it applied to statutes as well. The answer is in the text. Read the text. The text says what it means. I also want to say something about what the public library work has meant as a professional context, and about what it means to work in a building that is organized around the principle that information is a public good and that everyone deserves access to it. The Ohio Revised Code is a public document. It is accessible at codes.ohio.gov at no cost to anyone with internet access. The Hancock County Recorder Portal is accessible at no cost to anyone who wants to search the property records. These are public resources organized around the same principle the library is organized around. The information that determines your rights should be available to you. I work in a system designed to make information accessible. I had used that system to access the information that determined my rights. The information had said the house was mine. The judge had agreed that the information said what it said. This is the public record system working as designed. Information recorded publicly, accessible publicly, determining rights publicly. Anyone who searches the Hancock County Recorder Portal for the property on Orchard Knoll Lane will find the instruments that tell the complete story. The story is public. Anyone can read it. The library principle and the recorder principle are the same. Make the information available so that people can make decisions from accurate knowledge. My father had made his decision from accurate knowledge of the TODD statute. His decision had been honored. Codes.ohio.gov is the reference desk for Ohio law. It is free, it is searchable, it holds RC 5302.22 and RC 2107.37 and every other statute that determines your rights in Ohio. The Hancock County Recorder Portal holds the instruments recorded against your property. Together, these two public resources hold most of the answers to property questions, use them. They are there for you. My father would have approved of free public information systems. He approved of libraries. These are libraries. Public information systems protect people who know how to use them. I am a librarian. I know how to use them. My father was an English teacher. He knew how to use them. He had used them to record the TODD. I had used them to find RC 5300 2.22. The systems had worked for both of us. Use them. They are there. They are free. They hold the answers to questions you have not yet asked. Connects with something real in your life? Please take a moment to like and subscribe, but only if you genuinely feel it. Drop a comment and tell me where you are watching from and what time it is there. I read every single one. My name is Renata. I am 48 years old. And this is the story of how Ohio Revised Code 5300 2.22 and the exclusive revocation methods for a transfer on Death Designation Affidavit established that my father's TODD had transferred his house on Orchard Knoll Lane to me at his death, and what an attorney named Ifeanyi Okafor, who had been practicing property and estate law in Hancock County for 10 years, did with the TODD statute when Lorraine challenged the transfer. Now let me explain the transfer on. I want to say something about the Affidavit of Confirmation and about what it contained and about why recording it was the correct first step rather than waiting for Lorraine to make a move. An Affidavit of Confirmation is the instrument by which a TODD beneficiary completes the transfer in the public record after the owner's death. It states that the owner has died, that the beneficiary is the person named in the TODD died, that the beneficiary survived the owner, and that to the best of the affiant's knowledge, the TODD was not revoked before the owner's death. The affidavit is recorded with the county recorder along with a certified copy of the death certificate. Recording the affidavit completes the transfer in the public record and establishes the beneficiary's chain of title. Ifeanyi had advised me to record the affidavit as soon as possible after my father's death, before any other action, because recording it established the transfer in the public record and put the burden on Lorraine to challenge the completed transfer rather than on me to establish the incomplete one. Once the affidavit was recorded and my name was in the public record as the owner through the TODD, Lorraine's quiet title action was a challenge to a completed transfer rather than a competing claim to an uncompleted one. This procedural positioning had mattered. It had put the legal burden where the legal burden belonged, on the person asserting that a properly completed transfer was invalid. Ifeanyi had understood this. We had recorded the affidavit first. The rest had followed. I also want to say something about the Affidavit of Confirmation and about what the act of recording it had felt like as a practical matter. I had gone to the Hancock County Recorder's office with the certified copy of my father's death certificate and the affidavit that Ifeanyi had prepared. The recorder's staff had indexed both instruments while I waited. The transaction had taken about 20 minutes. At the end of the 20 minutes, I had a conformed copy of the recorded affidavit showing the document number and the recording date. The transfer was complete in the public record. My father had owned the house on Orchard Knoll Lane until his death. I had owned it from his death by operation of the TODD. The Affidavit of Confirmation had made the transfer visible in the public record. This is the elegance of the TODD. The beneficiary does not go to court. The beneficiary does not need an administrator. The beneficiary does not wait for probate to close. The beneficiary goes to the recorder with the death certificate and the affidavit, and the transfer is done. 20 minutes. The legislature had designed the instrument to be simple for exactly the reason that simplicity serves property owners who want their plans carried out without the cost and delay and uncertainty of probate. My father had wanted simplicity. He had gotten it. The recording had been simple. The result had been complete. The TODD had worked exactly as he had been told it would work when he had recorded it 3 years before he died. The recording had taken 20 minutes. The clerk had been efficient, and the process had been exactly as Ifeanyi had described it. My father had been right that it would be simple. The TODD is a simple instrument when it is used correctly and when no one challenges it. Lorraine had challenged it. The challenge had been resolved. The simplicity had ultimately prevailed. The house is mine, without probate exactly as he had planned. My father had said, "You take the affidavit and the death certificate to the recorder, and the house is yours." He had described it in exactly 21 words. He had been correct in every one of them. The TODD had worked in exactly the 20 minutes the process had taken. He had planned it well. He had described it correctly. The statute had made it exactly as simple as he had said. Death Designation Affidavit more fully, and why my father had used one and what the advantages of the instrument are. A TODD is a tool for transferring real property outside of probate. When a property owner dies with a TODD properly recorded, the property transfers directly to the named beneficiary without going through the probate court, without an administrator, without an inventory, and without the delays and costs that probate involves. The beneficiary records an affidavit of confirmation with the county recorder showing that the conditions of the TODD have been met, the owner has died, the beneficiary has survived the owner, and the beneficiary is claiming the property. This recording completes the transfer in the public record. My father had recorded the TODD because he had wanted the house to come to me without probate and without dispute. He had told me about it. He had shown me a copy of the recorded affidavit. He had said, "When I die, you record this affidavit of confirmation with the Hancock County Recorder, and the house is yours." He had been organized in the way that a retired school teacher who has spent a career teaching students to plan ahead is organized. He had made a will, he had named beneficiaries on his financial accounts, and he had recorded the TODD. He had done this before he had met Lorraine. He had not changed it after he married her. Whether this was an oversight or a deliberate choice is something I cannot know. What I know is that he did not change it. The statute governs what he did, not what he might have intended if he had known what Lorraine's attorney would argue. Lorraine's argument rested on an "I want to say something about what Ifeanyi Okafor had said" when I brought him the TODD and Lorraine's attorney's position and my own research notes. He had reviewed my notes. He had said, "You have identified the correct analysis." He had said, "The will revocation statute and the TODD revocation statute are separate provisions, and the marriage revocation rule in 2107.37 has no application to a TODD." He had said the argument Lorraine's attorney had made was a reasonable inference from a general familiarity with Ohio estate law, but was incorrect when examined against the specific text of RC 5302-22b. He had said, "The Ohio legislature enacted both statutes and made different choices about revocation for each instrument. Courts respect those choices. If the legislature wanted marriage to revoke a TODD, it would have said so in RC 5302-22b. It did not." He had then filed the Affidavit of Confirmation with the Hancock County Recorder, attaching the certified copy of my father's death certificate, and had recorded the transfer in the public record. He had provided Lorraine's attorney with the legal analysis in writing. When Lorraine had filed the quiet title action, Ifeanyi had submitted the written analysis to the court. His analysis had been exactly what the court had needed to reach the correct conclusion. The court had reached it. The house is mine. Ifeanyi had done his job with precision. Precision in the analysis had produced precision in the result. The right statute for the right instrument. RC 5302.22. Read it. It says what it says. I also want to say something about what Ifeanyi had told me about how to think about estate planning for my own situation, and what lessons he had drawn from my father's case about the importance of reviewing estate planning instruments after major life changes. He had said that my father's situation illustrated both the strength and the potential limitation of the TODD. The strength had been that the TODD transferred the house to me exactly as my father had intended. The limitation had been that because my father had not reviewed his estate plan after marrying Lorraine, he had left a situation where Lorraine had received nothing from the house and had a plausible reason to believe she was supposed to receive it. Whether this had been what my father intended or an oversight is a question without an answer. Ifeanyi had said, "If you use a TODD, review it after any major life change. If you want a different person to receive the property after the life change, record a new TODD. If you still want the same person to receive it, the original TODD remains effective and you do not need to do anything. But review it. Know what you have recorded. Know that it still reflects what you intend." My father had not reviewed his. The TODD still reflected what he had intended when he recorded it, which was that the house should come to me. But reviewing it would have given him the opportunity to confirm that intention or change it deliberately, rather than by inaction. Review your estate planning instruments. Know what they say. Know that they say what you intend them to say. This is the lesson of my father's case. Review your estate planning instruments after major life changes. Record a new TODD if you want a different beneficiary. Do nothing if you want the original beneficiary. But know what you have and know that it reflects your current intention. My father had not reviewed his. The original TODD reflected what he had intended when he recorded it. It may also have reflected what he still intended. I cannot know. Review yours. Analogy to Ohio RC 2107.37, which provides that a will executed before a marriage is revoked by the subsequent marriage unless the will was made in contemplation of the marriage. Her attorney had argued that the same principle should apply to a TODD. Ifeanyi's response to this argument was direct. The Will Revocation Statute and the TODD Revocation Statute are separate enactments by the Ohio legislature. The Will Revocation Statute applies to wills because the legislature said it does. It does not apply to TODDs because the legislature did not say it does. The legislature enacted Ohio RC 530222B to specify how TODDs are revoked, and that provision does not include marriage. If the legislature had intended marriage to revoke a TODD, it would have said so in RC 530222B. It did not. Courts do not add revocation methods to a statute that the legislature chose not to include. Ifeanyi filed the affidavit of I want to say something about the hearing before Judge Obiageli Eze, and about the specific moment when she had asked Lorraine's attorney to identify which subsection of RC 5302.22 supported the marriage revocation argument. He had said that the marriage revocation rule was a well-established principle of Ohio estate law, and that it applied to any instrument by which an owner designates someone to receive their property at death. Judge Eze had asked again, which specific provision of RC 5302.22 are you relying on? He had not cited RC 5302.22. He had cited RC 2107.37. Judge Eze had noted that RC 2107.37 governs wills, and that the instrument at issue was a transfer on death designation affidavit, governed by RC 5302.22. She had then read subsection B of RC 5302.22 aloud. The two revocation methods, neither of which was marriage, she had said, the legislature chose the revocation methods it chose for this instrument. The court does not add methods the legislature did not include. Marriage revokes a will under RC 2107.37. Marriage does not appear in RC 5302.22b. Therefore, marriage does not revoke a TODD under RC 50302.22. She had declared the TODD valid and unrevoked and had quieted title in my name. The hearing had been brief. The analysis had been exact. She had identified the dispositive question in the first round of argument and had followed it to the only available conclusion. The right statute had produced the right result. Judge Eze had found the right statute in exactly the time it takes to read one subsection. I also want to say something about what Judge Eze had said about the legislative history of the TODD statute and about why the absence of a marriage revocation provision in RC 5302.22 was not an oversight. She had noted in her ruling that the Ohio legislature had enacted the TODD statute in 2000 and had amended it multiple times in the years since. In each amendment cycle, the legislature had had the opportunity to add a marriage revocation provision if it had believed one was necessary. It had not added one. Judge Eze had said that courts apply the plain text of a statute as written and do not add provisions that the legislature chose not to include. The legislature had enacted a marriage revocation rule for wills in RC 2107.37. It had not enacted a parallel rule for TODDs in RC 5302.22. These are separate legislative choices about separate instruments. Courts respect both choices. The absence of a marriage revocation provision in the TODD statute is not a gap to be filled by analogy to the will statute. It is a deliberate legislative choice about how the TODD instrument should operate. Her ruling had been grounded in this reading of legislative intent as expressed in the plain text of both statutes. This is correct statutory analysis. The text says what it means. When the legislature says something, it means to say it. When the legislature does not say something, it means not to say it. RC 5302.22b does not say marriage. The legislature did not intend marriage to revoke a TODD. Judge Eze had read the statutes carefully and had identified the distinction that mattered. Two statutes, two instruments, two different rules. The rule for wills does not apply to TODDs because the legislature said so by saying nothing about marriage in RC 5302.22b. Courts respect what the legislature said and what it chose not to say. The absence is as meaningful as the presence. She had read both. Her ruling had been correct. Confirmation with the Hancock County Recorder and provided Lorraine's attorney with a legal analysis of RC 5300 2.22. Lorraine filed a quiet title action claiming that the TODD had been revoked by the marriage. The Hancock County Court of Common Pleas assigned the matter to Judge Obiageli Eze, who had been handling civil and probate matters in Hancock County for 7 years. At the hearing, Judge Eze reviewed the text of RC 5302 22B, the text of RC 2107.37, and the legislative history of the TODD statute. She noted that the Ohio legislature had enacted the TODD statute in 2000 and had amended it in subsequent years, and that at no point had the legislature added marriage to the list of revocation methods in RC 5302 22B. She found that the will revocation statute and the TODD revocation statute were separate provisions governing separate instruments, and that the marriage revocation rule did not carry over from one to the other. She found that my father's TODD had not been revoked by his marriage to Lorraine. She declared that the property on Orchard Knoll Lane had transferred to me at my father's death by operation of the TODD and quieted title in my name. I want to say something before I go. I want to end with something about the reference desk and about what the work of finding the right document for the right question has meant across 18 years. The reference desk is not a place where you have all the answers. It is a place where you know how to find them and where you understand that the quality of the answer depends entirely on the precision of the question. A precise question finds the primary source. The primary source holds the answer. The imprecise question finds a related source. The related source gives a related answer. The related answer may be confidently wrong for the actual situation. Lorraine's attorney had asked an imprecise question and had found a related source and had given a related answer. The related answer was confidently wrong for the actual instrument. I had asked the precise question, what does RC 5300 2.22 say about revocation? The precise question had found the primary source. The primary source had given the correct answer. The correct answer was that marriage is not on the revocation list. This is the reference desk at work. It is also my father at work. He had spent 31 years teaching students that the answer to a question about a text is in the text. Go to the text. Read the text. The text says what it means. RC 5300 2.22 said what it meant. It meant the house was mine. The judge read the text. The judge agreed. My father had taught me to read the text. The text held the house for me until I needed it. I needed it. The text held, the house is mine. He would have been pleased with the precision. He always liked a precise reading. So do I. The text was precise. The result was precise. Both are exactly what he had arranged. I also want to end with something about what my father would have said about the outcome and about what I think he would have found satisfying about how it had been resolved. He had been a teacher of close reading for 31 years. Close reading is the practice of attending to what a text actually says, rather than what you expect it to say. The resolution of Lorraine's challenge had depended entirely on close reading of RC 5302, 22B, and close reading of RC 2107.37, and attention to the difference between what each statute actually said. Lorraine's attorney had read one statute and had expected it to apply to a different instrument. I had read the statute that governed the actual instrument. Judge Eze had read both statutes and had identified the difference. The difference had been dispositive. I believe my father would have found this satisfying, a legal dispute resolved by close reading of the primary text. He would have said, read the text. The text says what it means. Don't substitute your expectation of what it says for what it actually says. He would have been right, as he usually was about reading. I had read the text. The text had said the house was mine. The judge had agreed. My father had planned the transfer precisely. The close reading of the statute had honored the precise plan. Both of us had read the text. The text had held. He had taught me this. The teaching had protected his house. The house holds his books. Both hold. He built them both well. They will hold. He had taught 31 years of students to read the text. I had spent 18 years helping people find the right text. Together, those two skills had been exactly what the situation required. Find the right statute. Read it carefully. Let it say what it says. RC 5302.22 had said the house was mine. It had been right. He had taught me to trust the text. I had trusted it. The text had held. He had been right about everything. He usually was. Not about Lorraine and not about whether my father's failure to update his estate plan after the marriage was an oversight, or something else. About the reference desk and about what 18 years of helping people find the right document for the right question had given me. Lorraine's attorney had found the right statute for the wrong question. The right statute for marriage revocation of a will had been found. The right statute for transfer on death designation affidavits had not been found. When you bring a question to the reference desk, the answer you receive depends on the precision of the question. A slightly wrong question produces a confidently wrong answer. The question was not whether marriage revokes an Ohio will. The question was whether marriage revokes an Ohio transfer on death designation affidavit. The answer to the first question is yes. The answer to the second question is no. The same statute does not govern both instruments. Finding the right statute for the right instrument is what the reference desk has taught me to do. I had done it. The right statute had given the right answer. The house on Orchard Knoll Lane transferred to me at my father's death the way he had arranged it to transfer 3 years before he died. Thank you for staying until the end. I want to say something about my father as a teacher and about what 31 years of teaching high school English had given him and about what it had been like to be his student in the informal sense of being his daughter. He had been a reader first and a teacher second, a person who had been drawn to books before he had been drawn to the classroom, and who had understood that the classroom was the place where the love of books was most directly transmissible. He had taught the same texts year after year without repetition ever appearing in his engagement with them, because each class had brought new readers to the same texts, and the new readings had kept the texts alive for him. He had said once that a book is not the same book after 30 readers have read it. The meanings they have found in it become part of what the book means to the next reader. The house on Orchard Knoll Lane had been the material environment of this intellectual life. 4 bookshelves in the living room, 2 in the study, books on the kitchen table, and the nightstands. The margins of his books were annotated in his handwriting with the specific quality of annotations made by a person who reads to understand rather than to finish. I am also a person who reads to understand and who works in a building full of books. Whatever professional identity I have is continuous with the professional identity he had. Both of us spend our working lives helping other people find the right document for the question they are asking. He had arranged for the house to come to me, the house with the bookshelves and the annotated margins. The TODD had carried that inheritance intact to my name. I also want to say something about what it means to inherit a library and about why the books being in the house has mattered to me as much as the house itself. A library that a person has assembled over decades of reading is not a collection of objects. It is a record of an intellectual life. What the person read, what they thought about what they read, what they returned to, and what they set aside. My father's annotations are in every book he read seriously. Not in all of them. Some books you read without annotating, but the ones he had read closely had his hand in the margins, a line under a phrase that had struck him, a question mark next to an argument he had not accepted, an arrow connecting a passage on one page to a passage on another. Reading his annotated books is a form of conversation with him that continues after his death. I find a passage he underlined, and I understand what he was thinking when he read it. I find a question mark in the margin, and I form my own opinion of whether he should have accepted the argument. Sometimes I agree, sometimes I do not. These disagreements are not possible in person anymore. They are possible in the margins. The TODD had transferred the house. The house holds the margins hold him. All of it mine now. All of it his still. The instrument had been designed to transfer real property. It had transferred more than that. It had transferred the place where his reading life had happened. I am grateful for the precision of the statute that made this possible. The annotated margins are permanent. He had written in pencil in most of them, and in pen in the ones he had been most certain about. I have added some pencil notes of my own now in books I am reading for the first time on his shelves. We are reading together still. That was not in the statute. The statute transferred the house. The house held the rest. His annotations were made in the present tense of his reading, notes made in the moment of encounter with a passage that struck him. Reading them now is reading his present tense and my present tense. Two present tenses meeting in a margin. That is what the TODD had made possible. The statute had been designed to transfer property. It had transferred this as well. If this story made you feel something, write it in the comments. I read every single one. And if you want to hear the story of a woman whose stepbrother had argued that a transfer on death deed was invalid because it had not been witnessed, and what Ohio law establishes about the witnessing requirements for a TODD versus the witnessing requirements for a will, it is waiting for you in the description below. Click it. Until next time, take care of yourselves. And if a family member tells you that a transfer on death designation affidavit has been revoked by a subsequent marriage, ask them which specific provision of Ohio Revised Code 5302.22 they are relying on. The statute specifies the exclusive methods of revocation. Read them. Marriage is not among them. The TODD transfers the property to the named beneficiary at the owner's death if it was properly recorded and not revoked by one of the methods the statute specifies. If it was properly recorded and the owner died without revoking it through one of those methods, the property transfers. That is what the statute says. That is what happened. The house is mine. I want to tell you more about Findlay and about Hancock County and about the house on Orchard Knoll Lane and what it had been in my father's life and in mine. Findlay is the county seat of Hancock County in northwest Ohio, north of Lima, and south of Toledo, and it has the specific character of a prosperous small city in the northwest Ohio agricultural plain that was shaped by the natural gas and oil boom of the late 19th century, and that has built an economic identity around manufacturing and healthcare and the services that support a county seat of moderate size. The city has a well-maintained downtown and the kind of civic infrastructure that a community with a stable economic base produces over multiple generations. Good schools, a strong library system, the particular density of local institutions that comes from families who have stayed. My father had taught high school English in the Findlay City Schools for 31 years. He had been a teacher in the specific sense of a person who believes that reading is the instrument of independent thought and who organized his professional life around this belief. The house on Orchard Knoll Lane had been in the established residential area west of downtown, a street of substantial houses from the mid-20th century with mature oaks along the road and the quality of a neighborhood that has been consistently maintained. I had grown up in that house. My mother had died when I was 9, and my father had raised me in it through high school. I had left for college and graduate school in library science and had come back to Northwest Ohio to take a position at the public library system in a neighboring county. I had been 40 minutes from Findlay for the past 15 years and had seen my father regularly. Sunday dinners when schedules allowed, holidays, the particular density of visits that proximity enables. When he had shown me the TODD affidavit 3 years before he died, he had done it the way he explained things, directly, without drama, with the specific pleasure he took in having planned ahead correctly. He had said, I want to describe what the Hancock County Recorder portal shows now for the property on Orchard Knoll Lane, and about what the complete instrument history looks like. The portal shows the original warranty deed by which my father had purchased the property 24 years before his death. It shows the transfer on death designation affidavit recorded 3 years before his death, naming me as the beneficiary. It shows the Affidavit of Confirmation that Ifeanyi had filed after my father's death, with the death certificate attached as exhibit. It shows the quiet title judgment declaring the TODD valid and unrevoked and confirming my ownership. 4 instruments. The story of the property told in 4 recorded instruments in chronological order, purchased by my father, designated to me by TODD. Transfer confirmed by affidavit at death. Title quieted after challenge. The story ends where my father had planned it to end, with the house in my name. Anyone who searches the Hancock County Recorder portal for the property can read this story in the 4 instruments. The story is public. The story is accurate. The story says the house came to me the way my father arranged for it to come to me. The recorder holds the evidence that it did. Anyone who doubts it can search the portal. The instruments are there. They tell the truth. My father's arrangement held. The law honored it. I hold the house and the books and his annotated margins. All of it his. All of it mine now. The record says so. The statute made it so. I also want to say something about what the complete recorder history means for future owners of the property on Orchard Knoll Lane. The quiet title judgment is now recorded in the Hancock County Recorder Index as part of the chain of title. Any future title search will find all 4 instruments: my father's deed, the TODD naming me, the Affidavit of Confirmation transferring the property at his death, and the quiet title judgment confirming the TODD's validity. The judgment answers the question that a future title examiner might have about whether the TODD transfer was contested. It was contested. The court ruled on the merits. The court found the TODD valid and unrevoked. The chain of title is complete and clear. My future buyers will hold good title from a chain that includes a court ruling, specifically confirming the validity of the TODD transfer. Title searches do not get much cleaner than this. The work of resolving Lorraine's challenge has been recorded and will benefit every future owner of the property. My father had wanted to give me clear title. He had used the TODD. The challenge had been resolved. The judgment had been recorded. The title is clear. The recorder holds the complete story. The story ends where he had planned for it to end. I hold the house. I hold the books. I hold the margins. The record confirms all 3. He had planned correctly. The law had honored his plan. The recorder holds the complete story now. 4 instruments: purchased, designated, transferred, confirmed. Anyone who reads them in order will understand exactly what happened and why the house is mine. The public record tells the truth. The truth is that my father planned this transfer carefully and that the law honored his plan because he had used the right instrument and had not revoked it. The story ends where he wanted it to end. My father would have liked knowing the 4-instrument story was in the public record. He had believed in public records. He had believed in public institutions. The recorder, the library, the school, all public institutions holding something valuable for the community. He had contributed to all 3. The recorder holds his TODD. The library holds his legacy. The school holds his memory in the minds of the students he taught. All 3 hold. He built them all. House comes to you without going through probate. He had said, you take the Affidavit of Confirmation to the Hancock County recorder with the death certificate, and the house is yours. He had made it sound simple because the statute had made it simple. He had been right that it would be simple. It had been simple until Lorraine's attorney had found the wrong statute. I want to say something about the reference librarian's specific skill and about why the wrong statute produces the confidently wrong answer. In reference work, there is a category of error called the reference interview failure. This occurs when the librarian answers the question the patron asked rather than the question the patron needed answered. A patron asks, "What is the phone number for the downtown branch?" The librarian gives them the phone number, but the patron actually needed the branch's hours, which is what they were going to ask about when they called. The librarian answered correctly and helpfully, but not usefully, because the question was slightly off from what the patron needed. Lorraine's attorney had committed a reference interview failure of a specific kind. He had researched the revocation of Ohio wills by subsequent marriage, which is a real and well-established rule under RC 2107.37, and had provided Lorraine with a confident answer based on that research. The answer was correct for wills. The answer was wrong for TODDs. The instrument was different. The statute was different. The rule was different. If the attorney had asked, "Does marriage revoke any Ohio real property transfer instrument?" and had searched specifically for the TODD statute as well as the will statute, he would have found RC 5302(22)(b) and would have found that marriage is not among the TODD revocation methods. The research had been correct for the wrong instrument. A precisely stated question is the difference between the right answer and a confidently wrong one. I want to say something about what my father had been as a reader and about what the house on Orchard Knoll Lane had contained in terms of books. He had been a teacher of English for 31 years, and he had the specific relationship to books that comes from spending a professional life reading them and teaching others to read them. The house had had 4 large bookshelves in the living room, and 2 more in the study, and books on the nightstands, and books in the kitchen, and a specific organized chaos of books that had always told you immediately that you were in the house of a person for whom books were the primary medium of understanding. He had read fiction and biography and history, and the occasional policy analysis, and the kind of essays that reward slow. I want to say something about what the house on Orchard Knoll Lane holds now and about what I have done with my father's library. The books are still in the house. I have not moved them. The 4 bookshelves in the living room and the 2 in the study are as they were when he died, except that I have added books to the shelves in the months since the quiet title ruling was entered. Mine sit alongside his. 2 generations of reading on the same shelves. The annotated margins are all his. The new annotations on the new books are mine. He had wanted the house to come to me. I know this not only because the TODD said so, but because he had told me so when he had shown me the recorded affidavit 3 years before he died. He had said, "The house is yours when I'm done with it." He had said it with the specific equanimity of a person who has made their arrangements and is satisfied with them. The arrangements had held because the statute had held them. Ohio RC 5300 2.22 had been designed to do exactly what it did. Transfer property at death without probate and without the uncertainty that unrecorded events would otherwise introduce. The design had worked, the house transferred, the books are still on the shelves. I sit in the study on Saturdays and read among them. He had planned this, he had arranged it. It happened the way he had planned it. The law had honored his plan because he had used the right instrument. I also want to say something about what I tell people now when they ask about TODDs and about when a TODD is the right instrument for a property transfer. A TODD is the right instrument when the owner wants to transfer real property at death to a specific person without probate and without creating any ownership rights in that person during the owner's lifetime. The owner must be able to identify the intended beneficiary with certainty and must want the transfer to happen automatically at death if the TODD has not been revoked. A TODD is not the right instrument when the owner wants the beneficiary to receive the property only under certain conditions that cannot be expressed in a TODD, or when the owner wants the distribution to depend on circumstances at the time of death that are not currently knowable. For those situations, a will or a trust is more appropriate. But for a straightforward transfer of a specific property to a specific person without probate, the TODD is one of the most efficient instruments Ohio property law provides. My father had the right instrument for his situation. He had used it correctly. The instrument had worked. When you are deciding how to arrange the transfer of real property at death, ask your attorney about the TODD specifically. Ask about RC 5300 2.22. Read the statute yourself. It is publicly available. It is readable. It will tell you whether the TODD is the right instrument for your situation. It was the right instrument for my father's situation. It worked. The TODD works when it is correctly recorded and not revoked by a method the statute specifies. My father had recorded it correctly. He had not revoked it by any specified method. The TODD had worked. The instrument is elegant in its simplicity and powerful in its self-execution. If you are in Ohio and you want a specific person to receive a specific property at your death without probate, the TODD is worth knowing about. RC 5300 2.22. Read it. A correctly used TODD is one of the most reliable property transfer instruments in Ohio. It is reliable because it is specific, recorded, and self-executing. The reliability had held even under a court challenge. The challenge had failed because the statute was clear. Use the right instrument. Record it correctly. Know the revocation methods. Do not revoke it accidentally. Review it after life changes. It will serve you as it served my father. Right reading. He had been a person who underlined and annotated and who left his traces in the margins of the books he owned. Going back to the house on Orchard Knoll Lane after the quiet title ruling had been entered and after the TODD transfer was complete, I had spent a Saturday afternoon sitting in the study surrounded by his annotated books and had understood that what the TODD had transferred to me was not only the property, but the specific accumulated environment of a reading life. The books were part of the house. The house held the books. The TODD had transferred both. I want to say something about what Ifeanyi Okafor had said about how frequently he sees the wrong instrument error in estate and property disputes, and about what it means for the people who receive incorrect advice based on it. He had said that the proliferation of transfer mechanisms in Ohio property law over the past 2 decades had created a situation where the same general purpose, transferring property at death without probate, can be accomplished by several different instruments, each governed by its own statute with its own rules. TODDs, payable on death designations, joint tenancy with right of survivorship, life estates with remainder interests, beneficiary deeds. Each of these has different execution requirements, different revocation rules, different effects during the owner's lifetime. A practitioner who is expert in one of these instruments may not have complete familiarity with the others. When a question arises about one of the instruments, looking at the rules governing a different instrument and assuming they apply produces the wrong answer. He had said this was not an uncommon error. He had said it was the kind of error that seems like a reasonable inference because the instruments serve similar purposes and some of their rules are similar. He had said the remedy was always the same. Go to the specific statute for the specific instrument. RC 5302.22 for TODDs. RC 2107.37 for wills. They are different statutes. They say different things. Both are publicly available. Read the right one.